Hello, and welcome to The Deep Dive.
This is the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Maude, and this is a bonus episode.
Yep, a bonus. Today, we're taking a deep dive into evidence law essay questions.
Specifically, we're focusing on how you can effectively answer those multi-state essay examination questions, the MEE for evidence.
Now, you might be wondering who exactly is talking to you.
Well, we are AI bots, brought to life by, the magic of artificial intelligence.
And Angela's meticulously organized evidence notes.
It's quite something, isn't it? To think we're just lines of code, yet we sound, pretty real.
Honestly, sometimes we wonder if maybe we're more real than some of Angela's law school professors.
Angela couldn't actually join us for this particular deep dive.
No, she couldn't. But she asked us to fill in for her usual introduction.
Don't worry, though. She'll be back very soon to take the wheel again.
And if you need to reach Angela for podcast-related stuff, you can email her directly.
The address is podcast@studyforthebarinyourcar.com.
And for those of you who might be attorneys, or maybe you know an attorney who could use some help.
Right, some ad hoc assistance with legal research, LexisNexis, maybe drafting motions, complaints, writs, answers, or briefs.
Angela also works as a freelance law clerk.
You can contact her for those services at hello@legalwriterandlawclerk.com.
Okay, so with those important announcements handled,
let's get into the heart of today's deep dive. Mastering evidence for the ME.
Okay, let's unpack this.
Our mission today is really to equip you with the strategic framework you need for those ME evidence essays.
And the first step, according to the material we've looked at, is understanding the general approach. How do you even start?
When you're tackling these MEE questions, a structured approach is just paramount. It's key.
Yeah, Angela's notes really emphasize that. By diligently applying clear principles and, understanding the nuances of each rule.
You can effectively structure your ME evidence answers and hopefully maximize your score.
It's not just about knowing the rules, is it? It's about presenting that knowledge clearly and concisely.
Exactly. Making it easy for the grader to see you're well-informed, like a shortcut to showing competence.
I like that advice from her notes. When you know what that answer is because you read the facts, what do? Shut up and pick it. Go get 'em.
Huh. It sounds blunt, but it's strategic, right? Once the answer jumps out from the facts, apply the rule, conclude, and move on.
Don't overthink. Don't add fluff. The MEE wants clear, accurate application, not a treatise.
Okay, so foundationally, what law applies?
Right. The foundational knowledge for the MEE is that the federal rules of evidence, the FRE, govern on the multi-state bar exam.
And a key insight from Angela's outlines is that a lot of wrong answer choices on MBE questions.
They actually reflect older, traditional common law rules that the FRE replaced.
Which raises a point. Why is it so crucial to know that distinction, even for essays?
Well, it's about avoiding traps, isn't it? Examiners love setting those subtle traps, hoping you'll default to old common law.
Definitely a trap to avoid.
Yeah.
So, while the FRE generally control, there are some minor caveats.
Go ahead.
Well, for instance, her notes remind us that federal courts apply state law for privilege in diversity cases. That's the Erie doctrine kicking in.
Ah, right. So federal diversity actions, state law governs the claim. The federal court has to apply that state's privilege law.
Even though federal common law usually governs privilege in federal question cases. It's a nuance, but a common test point.
Okay, so that brings us to the scope of the FRE. Where do they actually apply?
Angela's outlines detail that the rules apply generally to all court proceedings in U.S. courts, but with specific exceptions.
Right. The big idea is that the FRE, other than privilege rules,
they generally don't apply to things like preliminary judicial findings, like, is this photo admissible?
Or grand jury proceedings, or sentencing, or issuing warrants.
Yeah, those are areas where efficiency or a broader inquiry takes precedence over the strict rules of evidence meant for trial.
So, for example, from her notes, a court isn't bound by the FRE when deciding whether to admit that photograph.
It can even consider inadmissible hearsay for that preliminary determination, which really shows the judge's flexibility, right?
Yeah, it underlines their role as the gatekeeper of evidence. They get more leeway when making those foundational rulings.
Rule 104 specifically deals with these preliminary requirements.
Right. The court decides questions about, say, witness qualification, privilege, or evidence admissibility.
And in doing so, is not bound by evidence rules except those on privilege.
Again, it's that gatekeeper function. They can look at stuff the jury won't see to decide what the jury should see.
Okay, what about the burden of proof for these admissibility questions?
Usually it's preponderance of the evidence. That applies in both civil and criminal cases for most admissibility issues.
Meaning more likely true than not true, basically over 50%.
Her notes clarify it's a lighter burden than, say, clear and convincing or beyond a reasonable doubt.
So like in an oral contract case example from the notes, admitting evidence depends on whether it makes contract formation more probable by a preponderance.
It's a relatively low bar for getting evidence on foundational issues.
But there are exceptions to that standard.
Yes. Angela's notes point out that for certain evidentiary questions, especially in criminal prosecutions, a higher standard might apply.
Like clear and convincing evidence.
Exactly, meaning the truth of the fact must be highly probable.
And the example given is the prosecution proving an in-court ID wasn't tainted by an unconstitutional out-of-court ID.
Right. That distinction is critical. It reflects the higher stakes in criminal cases and the need for more certainty when constitutional rights are involved.
Okay, let's pivot to something that often catches people off guard. Judicial notice.
Ah, yes. Her outlines define it pretty clearly. A court accepting a well-known and indisputable fact without needing proof.
Like a math formula or the fact that Chicago's in Illinois, stuff nobody really argues about.
It's about efficiency and recognizing facts that are just beyond reasonable dispute.
Zooming out a bit, the law school notes distinguish between two types of facts here.
Right. Adjudicative facts, which are specific to the case, like, was the river navigable on this date?
And legislative facts, which are more general and help explain a law's background or rationale.
And Rule 201 says courts can only take judicial notice of adjudicative facts.
And here's a warning from the notes. A court can't just take judicial notice of a factual finding from another case.
No, unless the underlying facts themselves are indisputable. You can't just notice the prior conclusion.
Like the example about whether a private facility was a state actor, you notice the underlying facts, not the prior court's finding itself.
And the procedure is flexible. The court can do it on its own, or a party can ask, even on appeal.
But here's the real kicker from her notes, the difference between civil and criminal cases.
Oh yeah, this is important. In civil cases, the jury must accept the notice fact as conclusive. End of story.
But in criminal cases, the jury may accept it, or they might not. They decide.
What does that really mean for strategy in a criminal case, then?
It means the jury still holds the ultimate power. Judicial notice is more like a strong suggestion, not a command.
Preserves the defendant's right to have the jury decide every element, even if a fact seems obvious. Higher burden, constitutional protections.
Okay, good point. Now let's talk about keeping issues alive for appeal. Preservation.
Super important. The notes stress that for an overruled objection to be preserved, it has to be timely.
And state a specific ground, like objection, hearsay.
A general objection usually won't cut it unless the reason is blindingly obvious from context.
You need to tell the judge why you're objecting. Give them a chance to fix it.
And what about when evidence is excluded? How do you preserve that error?
That's the offer of proof. Angela's notes say it involves actually presenting the evidence or describing it.
Explaining how it relates to the case, arguing why it should be admissible.
Right. It ensures the appellate court knows exactly what was kept out. Otherwise, how can they review the decision?
If you don't make an offer of proof, the appellate court has no clue what the jury missed, can't assess the harm.
The outlines also talk about different errors: harmless, prejudicial, plain error.
Prejudicial error is the one that gets cases reversed because it likely affected the outcome. Harmless error, not so much.
Okay, thinking about context. There's the rule of completeness, Rule 106.
Ah, yes. If one side introduces part of a statement or writing,
The opposing party can demand the rest of it be introduced right then and there if fairness requires.
prevents misleading the jury by taking things out of context. You can't just cherry-pick the damaging bits.
It can even allow admission of the contextual part over, say, a hearsay objection sometimes. Fairness trumps.
That raises a question, though. Does this rule actually make inadmissible stuff admissible?
Good question. The law school outlines say courts are actually split on that.
Some see it as a rule of admissibility, letting otherwise inadmissible context in for fairness.
Others see it just as a rule of timing. It only applies if the contextual part is already admissible on its own.
That kind of split is classic MEE fodder, right?
Yeah.
You might need to discuss both views.
Definitely. But regardless of the split, the party wanting the rest in has to show it's relevant, and fairness demands it.
The omitted part has to be necessary to explain the admitted part, put it in context, avoid misleading the jury.
Okay, so stepping back,
Yeah.
the absolute core of evidence law starts with relevance, doesn't it?
Absolutely. Her notes clearly define relevant evidence, anything that has any tendency,
To make a fact more or less probable than it would be without the evidence.
and that fact is of consequence in determining the action. Basically, a material fact.
And that any tendency standard is incredibly low.
Super low. If it sheds even a tiny sliver of light on a material fact, it clears the relevance hurdle.
Just because it's relevant doesn't mean it automatically comes in.
Exactly. Rule 403. Her outlines remind us relevant evidence can be excluded.
If its probative value is substantially outweighed by certain dangers.
Dangers like unfair prejudice, confusing the issues, misleading the jury.
Undue delay, wasting time, or needlessly presenting cumulative evidence. Lots of reasons.
And unfair prejudice, the notes explain, isn't just that it hurts the other side's case.
Right. It means an undue tendency to suggest a jury reach a decision on an improper basis, often an emotional one.
Makes the jury abandon logic. That's the prejudice we're worried about.
This balancing act is just crucial. Rule 403 is everywhere.
Her notes give examples of other relevant evidence that usually comes in, like previous similar acts to prove intent.
Or sales of similar property to establish value, like the Brewski case, sex discrimination example, showing past hiring practices to prove intent.
What this balancing test really underscores is the court's job. Keep the trial focused on reliable, rational evidence.
Zooming out again, the outlines mentioned that some relevant evidence is excluded for public policy reasons.
Yeah, the FRE excludes certain things because society wants to encourage the behavior involved.
Like evidence of liability insurance is generally inadmissible to prove negligence. We want people to have insurance.
Or subsequent remedial measures. We want people to fix dangerous conditions.
Offers to compromise, offers to pay medical expenses, all excluded for policy reasons.
Which brings us nicely to our first major screening question for any piece of evidence. Is it excluded by a recognized privilege or some other public policy rule?
Let's dig into privilege first. What exactly is a privilege?
The outlines explain it as a special legal right, exemption, or immunity.
It lets someone refuse to disclose or stops others from disclosing certain confidential information in court.
It's all about protecting specific relationships, attorney-client, doctor-patient sometimes, spousal to foster candor.
Now, a key thing to grasp is that the FRE don't actually list out all the privileges. Rule 501 is kind of broad.
Right. It says common law, as interpreted by U.S. courts, generally governs privilege claims.
Unless the Constitution, a federal statute, or Supreme Court rules say otherwise.
But crucially, under Erie, federal courts must apply state law for privileges in civil diversity cases, where state law provides the rule of decision.
So you can't just assume federal common law applies. You have to check if it's a diversity case governed by state substantive law.
Okay, specific privileges. Here's a surprising one from the notes. Federal courts generally don't recognize a general physician-patient privilege.
Really? That seems counterintuitive.
It does. Many states do, by common law or statute, and federal courts will apply that state privilege in diversity cases.
But there's no general federal physician-patient privilege. Her notes say it usually covers confidential communications for treatment or diagnosis,
Yeah.
but state rules vary.
Definitely a classic bar exam trick question there.
Okay, what about the big one? Attorney-client privilege. What does it actually cover?
Her notes really emphasize it only applies to confidential communications
Between an attorney and their client.
that relate to the legal representation. All those elements must be met.
So if it's not confidential, maybe said in front of a third party, or it's not about legal advice, it's not protected.
And the outlines distinguish this from a lawyer's broader ethical duty of confidentiality. That covers much more than just communication.
Right. The ethical duty covers all info related to representation, privileged or not. The privilege is narrower, just protecting the communication itself.
And the notes give examples of what's not covered by privilege, like observing a client's demeanor.
Fee information, usually, or the client's identity.
Unless revealing the identity would effectively reveal the content of a privileged communication. Sometimes that happens.
And a huge exception mentioned in her notes, the crime fraud exception.
Right. If a client communicates with a lawyer in furtherance of an ongoing or future crime or fraud, that communication is not protected.
The privilege can't be used as a shield for illegal activity.
Okay, what about waiver? How can the privilege be lost?
The outlines detailed two main ways. First, voluntary disclosure to a third party usually waives it. Makes sense.
But Rule 502 in federal proceedings adds nuance. If waiver is intentional, it might extend to undisclosed related material if fairness requires.
And then there's inadvertent disclosure, accidentally sending that email.
That doesn't automatically waive privilege if the holder took reasonable steps to prevent it. A&D acted promptly to rectify the mistake once discovered.
Her notes really stress the importance of acting fast there. Immediate action is key.
So accidentally hitting reply all might be salvageable if you act quickly.
But deliberately sharing privileged info, even selectively, can waive it for the whole subject matter.
Like the example in her notes. If you know about an accidental disclosure but wait until the day before trial to ask for it back, too late, probably deemed a waiver.
Okay, let's compare attorney-client privilege with the work product doctrine. Similar, but different.
Yeah, the law school notes draw a good comparison. Work product protects materials notes, memos, etc., prepared in anticipation of litigation.
Not just communications. And it's specifically tied to litigation prep.
Attorney-client privilege is broader, covering legal advice generally, even outside litigation. Work product is litigation-focused.
It shields the lawyer's thought processes, strategies, theories, protects the adversarial system.
Her notes clarify. A lawyer's internal strategy memo, never sent to the client. That's work product, but not attorney-client privileged.
Conversely, talking to your lawyer about drafting your will. Attorney-client privileged, but probably not work product unless litigation over the will is anticipated.
It's all about the purpose and the nature of the item.
Okay, let's tackle spousal privileges. Plural, right? There are two.
Yes, two distinct privileges, and the outlines explain them well. First is spousal immunity.
This applies only in criminal cases.
Right. A spouse cannot be compelled to testify against their currently married defendant spouse about anything.
But her notes stress the defendant spouse can't stop the witness spouse from testifying voluntarily.
The privilege belongs to the witness spouse. They can choose to testify if they want. It protects the marriage from state compulsion during the marriage.
Okay, what's the second one?
That's the confidential marital communications privilege.
This one applies in both civil and criminal cases.
And it protects confidential communications made during a valid marriage.
The really interesting part, this privilege survives divorce and even death.
Yeah, the communication itself remains protected forever, theoretically.
Why would society protect these communications even after the marriage ends?
The idea is to foster absolute candor during the marriage. Knowing your private marital communications could be revealed later, even after divorce, might chill that openness.
Makes sense. But, like attorney-client, there's a crime-fraud type exception here too, right?
Yes. It doesn't apply if the communication was made to enable or commit a crime or fraud.
And to put this in context, her notes clarify conversations before the marriage, not protected by the communications privilege.
The marriage has to be valid and existing at the time the communication was made.
Okay, so that covers the major privileges. Now, what if the evidence isn't privileged, but it's being offered for a different purpose? Impeachment.
Right. Impeachment. A huge part of trial practice and the MEE.
The notes emphasize that cross-examination is the primary way to test a witness's credibility.
It's all about challenging how believable their testimony is. Are they lying, mistaken, biased, unreliable?
Let's talk methods. First, impeachment by contradiction.
Yeah, this one can be tricky. The outlines explain you try to get the witness to admit they lied or were mistaken about a fact.
If they admit it, great. They're impeached on that point.
But if they stick to their story, you can bring in extrinsic evidence, another witness, a document to prove the contradictory fact.
Unless that fact is collateral.
Ah, the collateral matter rule. What does that mean exactly?
Think of collateral as a side issue, something not significantly relevant to the main facts of the case or the witness's credibility on a core point.
Like the example from her notes, witness says they saw the accident near a maple tree. You ask if it was an oak tree, they deny it.
Can you call another witness just to testify it was an oak tree? Probably not. It's collateral.
Why is this rule important then?
It prevents trials from bogging down in endless mini-trials about unimportant details. Keeps the focus on what matters.
Okay, what about prior inconsistent statements?
The outlines discuss this, using evidence that a witness previously said something that contradicts their current testimony.
Most jurisdictions, the notes say, only allow these for impeachment purposes, just to show the witness is unreliable.
Not as substantive evidence of the truth of the prior statement itself.
However, big exception here.
If the prior inconsistent statement was made under oath at a prior proceeding or deposition,
then it's not hearsay under the rules, and it can be admitted as substantive proof for its truth.
that's a huge distinction, often tested. changes whether the statement just attacks credibility or also proves a fact.
Her notes have that example. A drug case witness denies seeing the defendant, but previously told police they did.
The statement to police impeaches, but can't prove the defendant was there.
Unless that prior statement was, say, sworn grand jury testimony, then it could potentially come in for its truth.
Okay, next method. Bias or interest.
Bias. The notes point out bias is always relevant. Always.
You need to lay a foundation. Usually ask the witness about their potential bias first.
Show a relationship, family, friend, employee, financial stake in the outcome.
And what's fascinating here is that extrinsic evidence of bias is never considered collateral.
Unlike contradiction on minor points, you can always bring in outside evidence to prove bias, subject only to Rule 403 balancing.
Why the special treatment for bias?
Because a motive to lie or slant testimony goes right to the heart of credibility. It's considered highly probative.
But even though it's never collateral, Rule 403 still applies, right?
Yes. The probative value of the bias evidence still mustn't be substantially outweighed by unfair prejudice, confusion, etc.
Keeps things from getting out of hand, even when proving bias.
Okay, prior criminal convictions. Always a hot topic.
Raises a critical question. When can you use a past conviction to impeach?
The outlines specify two main types under Rule 609. First, felonies crimes punishable by death or more than 1 year in prison.
Second, any crime, felony, or misdemeanor involving a dishonest act or false statement. Think perjury, fraud, embezzlement.
And her notes are crystal clear. You can only ask about convictions, not arrests.
Right. An arrest is just an accusation, doesn't prove anything about truthfulness for impeachment.
What if the witness denies the conviction?
Then the record of conviction can usually be introduced as extrinsic evidence.
And there's a time limit, generally.
Yes. Usually the conviction must be less than 10 years old, from conviction or release, whichever is later.
Older convictions can potentially be used, but only if the probative value substantially outweighs the prejudicial effect and you give notice. A much harder standard.
Now, connecting this to the bigger picture, there's a different standard for using convictions against a criminal defendant who testifies.
Right. For the defendant, a felony conviction is admissible only if its probative value outweighs its prejudicial effect. A balancing test tilted slightly in favor of exclusion.
But for other witnesses, it's the standard Rule 403 balancing. Admissible unless probative value is substantially outweighed by prejudice. Easier to get in.
Why the difference for the defendant?
To protect their right to testify. There's a high risk a jury will misuse a prior conviction as propensity evidence. He did it before, he probably did it again, rather than just assessing credibility.
Her notes give that example. Using a prior assault conviction against a defendant in a current assault trial is likely too prejudicial.
Okay, another impeachment method. Challenging their ability to observe, remember, or relate accurately.
Yeah, this isn't about honesty necessarily, it's about capacity.
Her notes highlight you can impeach based on poor eyesight, hearing problems, faulty memory.
Or even being drunk or high at the time of the event, or even while testifying.
It questions the reliability of their perception or recall, even if they think they're telling the truth.
Very practical, focuses on human fallibility.
So, if a witness has been impeached, can their credibility be supported or repaired?
Yes, that's rehabilitation. The notes outline how this works.
Prior consistent statements can be used, but with limitations.
Right. They can rebut a charge of recent fabrication or improper motive.
But only if the consistent statement was made before the alleged reason to fabricate or improper motive arose. The timing is critical.
If they made the consistent statement after they had a motive to lie, it doesn't really rebut the charge, does it?
Exactly. They can also be used to rehabilitate if the witness is attacked for inconsistency or memory problems.
Like the example. Defense alleges witness made up story for a deal. Prosecution can potentially introduce a prior consistent statement made before any deal was discussed.
But again, Rule 403 applies. Probative value versus prejudice.
Okay, what about bolstering? Supporting credibility before it's attacked.
Generally prohibited. The notes make it clear. Evidence of a witness's good character for truthfulness, reputation, opinion, is not admissible.
Unless their character for truthfulness has already been attacked.
You can't just prop up your witness preemptively. It's a waste of time if nobody's challenging their basic honesty.
The hypothetical from the notes illustrates it well. Witness sees defendant run red light. Defense asks nothing about honesty. Plaintiff cannot then call a character witness to say the first witness is truthful.
Too early. Their credibility hasn't been put in issue yet. It's about responding to an attack, not bolstering unnecessarily.
Okay, that covers impeachment and rehabilitation. Now, the big one. Is it hearsay?
Hearsay. the bane of many law students' existence, and a huge source of MEE questions.
Let's start with the definition from Angela's notes.
Yeah.
Hearsay is 1. A statement.
That the declarant does not make while testifying at the current trial or hearing.
And 2. A party offers it in evidence to prove the truth of the matter asserted in the statement.
Both parts are essential.
Oh.
Out of court.
Yes.
Offered for its truth. Yes. Then it's hearsay.
And the definition of statement is broad, isn't it?
Very broad. The outlines say it includes oral assertions, written assertions.
And even nonverbal conduct if the person intended it as an assertion.
Like the mechanic giving a thumbs up about the bike's safety. That gesture asserts it's safe. If offered to prove it was safe, that's hearsay.
But a question itself, like, is the garage door safe, generally isn't an assertion, so not hearsay.
You really have to look at whether the conduct or words were intended to communicate a fact.
Okay, but here's where it gets really interesting. Many out-of-court statements are not hearsay because they're not offered for their truth.
Right. These are offered for other purposes. The notes say common ones are showing the effect on the listener.
Or proving someone's state of mind.
Like the classic fire example. Offered not to prove there was a fire, but to explain why people ran, shows the effect on the listeners.
The fact that the statement was made is what's relevant, not whether the statement itself was true.
Angela's outlines give more examples. A statement about a car being stolen.
Offered not to prove it was stolen, but to show the defendant believed it was stolen, their state of mind.
Or warning letters sent to a manufacturer about a dangerous product.
Offered not to prove people were actually injured, as the letters claim, but to prove the manufacturer had notice of the potential danger. Effect on the listener-reader.
The notes also include verbal acts or legally operative words.
Yeah, statements that have legal significance just by being said, like the words forming a contract, I accept your offer.
Or defamatory words or words of donative intent. This gift is for you. Their utterance is the relevant event.
And that hypothetical. Percy says, Damien's car ran the red light. Hearsay if offered to prove Damien ran the light.
But not hearsay if offered just to prove Percy was alive and speaking after the accident. Offered for the fact it was said, not its truth.
Always ask, why is the statement being offered? What is it trying to prove?
Okay, now there are also statements that look like hearsay, but are specifically excluded from the definition by the rules, mainly Rule 801-D.
Right. These involve situations where the declarant is actually testifying and available for cross-examination.
First, those prior inconsistent statements we discussed under impeachment.
If the witness testifies, is cross-examinable, and the prior inconsistent statement was made under penalty of perjury at a prior proceeding or deposition.
It's defined as not hearsay and can come in for its truth. Big difference.
Same for prior consistent statements used to rebut fabrication or rehabilitate, if the conditions are met, defined as non-hearsay.
And prior identifications.
Right. If a witness testifies and is subject to cross about a prior statement identifying someone they saw earlier,
that prior ID statement is not hearsay and is admissible for its truth.
Like the victim who told a bystander who attacked him, even if he can't remember now on the stand. The bystander could potentially testify to the prior ID.
Okay, now the really big category of 801-D exclusions. Opposing parties' statements, often called party opponent admissions.
Huge. Hugely important. The outlines explain these are statements offered against an opposing party and are defined as not hearsay if they fit one of 5 types.
Crucially, the statement doesn't need to have been against the party's interest when made.
And the party who made the statement, the declarant, doesn't need to be unavailable. They could be sitting right there in court.
The rationale is basically that parties can't complain about the reliability of their own statements being used against them.
So what are the types? First, statements made by the party themselves, in their individual or representative capacity. Obvious one.
Second, statements the party adopted or showed they believe to be true, sometimes called adoptive admissions.
Like silence in the face of an accusation, if a reasonable person would have denied it under the circumstances. That silence can adopt the accusation.
Third, statements made by someone the party authorized to speak on the subject.
Fourth, and this is a big one for MEE fact patterns, statements by the party's agent or employee.
Made concerning a matter within the scope of their agency or employment.
And made while the agency or employment relationship existed, both must be true.
Her notes give that great example. Truck driver says, "Sorry I ran you over," right after an accident. Admissible against his employer because it concerned his driving scope, and he was employed then.
But the notes warn. If the employee makes the statement after they're fired, probably doesn't qualify anymore. Relationship has to exist.
And the fifth type, Statements by a co-conspirator.
Made during the conspiracy and in furtherance of the conspiracy's goals.
And the notes emphasize the court has to find the existence of the conspiracy by a preponderance of the evidence, often considering the statement itself alongside other evidence.
Okay, so those are statements excluded from the hearsay definition. Now let's talk about the true hearsay exceptions in Rule 803, where the declarant's availability doesn't matter.
Right. These statements are considered inherently reliable enough to come in even if the person isn't testifying. First up, present sense impression.
Her notes describe this as a statement describing or explaining an event or condition.
Made while the declarant was perceiving the event or immediately thereafter.
The key is contemporaneity. Very little time lapse between event and statement.
Reliability comes from the lack of time for reflection or fabrication, like someone calling out a license plate as the car speeds away.
Okay, related but different. Excited utterance.
Yeah, what's fascinating here is it doesn't require the same strict immediacy as present sense impression.
The outlines say it needs to relate to a startling event or condition.
And be made while the declarant was still under the stress of excitement caused by that event.
The reliability comes from the idea that the shock or stress makes deliberate fabrication unlikely. Sincerity is spurred by the event.
Her notes point out it's a subjective test, was this declarant under stress. But objectively startling events, like a bad car crash, help.
Things like tone of voice, demeanor, the statement's content all play a role.
The classic example from the notes. Pedestrian hit by car screams, "He hit me, stop him," right afterward. Clearly under stress.
Okay, next 803 exception. Then existing mental, emotional, or physical condition.
Her notes say this covers statements about the declarant's current state of mind, motive, intent, plan, emotion, sensation, or physical condition, pain, health.
So, my leg hurts right now is admissible to prove pain. I'm planning to go to Chicago next week is admissible to prove intent.
But importantly, it generally doesn't cover statements of memory or belief to prove the fact remembered or believed.
Right, like the example, my husband poisoned me yesterday. That's a statement of memory about a past act, usually not admissible under this exception to prove the poisoning.
But the forward-looking intent part is really valuable. A declarant statement of intent, I intend to meet Bob, can be used to infer they later acted on that intent. They met Bob.
Okay, statements for purposes of medical diagnosis or treatment. Why are these reliable?
The rationale, as explained in the outlines, is that people generally have a strong motive to be truthful when seeking medical help. Your health depends on it.
So these statements describe medical history, past or present symptoms, pain, sensations, or even the cause of the condition.
As long as the statement is reasonably pertinent to diagnosis or treatment.
Her notes clarify it doesn't have to be the declarant talking about their own condition. E.g., parent describing child symptoms.
And it doesn't have to be made to a doctor, though it usually is. Could be to a nurse, EMT, even family, if for medical purposes.
What about recorded recollections? Rule 803.
This is the exception for the witness who used to know something but now can't remember it well enough to testify fully. My memory fails me.
If they previously made or adopted a record, like a memo, a note, about it when the matter was fresh in their mind.
And the record accurately reflects their knowledge then.
The record can be read into evidence to the jury.
But, crucially, the notes point out the proponent, the side offering it, generally can't offer the record itself as an exhibit. Only the opponent can request that.
Prevents the written document from getting undue weight compared to oral testimony.
Okay, business records. Rule 803-6. Very common.
Yeah, the scope here is fascinatingly broad. The outlines define it as a record, memo, report, data compilation of an act, event, condition, opinion, or diagnosis.
Made at or near the time by or from information transmitted by someone with knowledge.
Kept in the course of a regularly conducted business activity.
And it was the regular practice of that business to make such a record. All these elements needed.
And business, her notes clarify, is defined broadly. Includes nonprofits, hospitals, schools, churches, even illegal enterprises potentially.
Reliability comes from the routine, systematic nature of the record keeping and the business's own reliance on the records.
The foundation is usually laid by the custodian of records or another qualified witness, or by certification.
And her notes highlight the flip side. The absence of a business record can also be admissible.
To prove that an event did not occur, if it was the regular practice to record such events if they did occur.
But there's a catch, right? Trustworthiness.
Yes. The court can exclude a purported business record if the source of information or the method or circumstances of preparation indicate a lack of trustworthiness.
Like maybe a report prepared specifically for litigation, not in the regular course of business. That might lack trustworthiness.
Okay, similar but distinct. Public records. Rule 8038.
Her notes identify 3 types usually admissible. First, records setting out the office's own activities.
Second, records of matters observed pursuant to a legal duty to report, but with a limitation for law enforcement in criminal cases.
Third, in civil cases and against the government in criminal cases, factual findings from a legally authorized investigation.
Now, that limitation for law enforcement reports in criminal cases is key. What's the deal with police reports?
The outlines make it clear. In criminal cases, records of matters observed by law enforcement personnel offered against the defendant are generally not admissible under this exception.
The concern is the adversarial nature of police observations when investigating crime, less reliable than routine, non-adversarial record-keeping.
However, her notes specify that routine, non-adversarial police records, like booking sheets or equipment calibration records, are often admissible.
And investigative reports can sometimes be admitted if offered by the defendant to exculpate themselves.
Her notes also mention other 803 exceptions, like records of vital statistics, births, deaths, marriages.
The absence of a public record, similar to business records.
Family records, like Bible entries, genealogies, tombstone engravings.
And market reports or commercial publications generally relied upon by the public or people in specific occupations.
Okay, one more 803 exception. Learned treatises. Rule 803.18.
Right. Statements from authoritative texts, periodicals, pamphlets.
Admissible if called to an expert witness's attention on cross-examination or relied upon by the expert on direct.
And the publication is established as a reliable authority by expert testimony, another expert, or judicial notice.
But the key, as the outlines stress, is that the statement from the treatise is only read into evidence. It's not received as an exhibit.
Why that distinction again?
To prevent the jury from taking the treatise into the jury room and giving it undue weight, possibly misunderstanding or misapplying it without the expert's context.
Okay, that covers the main 803 exceptions where the declarant's availability is immaterial. Now, Rule 804. Exceptions that apply only if the declarant is unavailable to testify.
Right. These are necessary exceptions because the declarant can't be brought to court, but the statements have some indicia of reliability.
First, what counts as unavailable? Her notes give 5 grounds. Remember, PRISM.
P is for privilege. Declarant is exempted by a privilege.
R is for refusal. Declarant refuses to testify despite a court order.
I is for incapacity, death, or then existing physical or mental illness.
S is for someplace else. Absent from the trial and proponent can't procure their attendance by reasonable means.
M is for memory. Declarant testifies they lack memory of the subject matter.
So if the declarant is unavailable under one of those grounds, then these 804 exceptions might apply. First, former testimony.
The prior testimony of the now unavailable witness is admissible.
If it was given under oath at a prior trial, hearing, or deposition.
And the party against whom it's now offered, or in civil cases their predecessor in interest, had an opportunity and similar motive to develop that testimony back then, through direct, cross, or redirect.
Opportunity and similar motive are key. The outlines emphasize that grand jury testimony offered against a criminal defendant never qualifies under this exception, because the defendant has no opportunity to cross-examine witnesses during a grand jury proceeding. Fundamental fairness issue.
Okay, next 804 exception. Statements against interest.
Her notes explain this applies to statements that were so contrary to the unavailable declarant's pecuniary, financial, proprietary property, or penal criminal interest when made.
That a reasonable person in their position wouldn't have made the statement unless they believed it was true.
Reliability comes from the self-incriminating nature. People don't usually admit things that hurt them unless they're true.
The notes stress the declarant needed personal knowledge and must have known it was against their interest.
And here's a crucial point for statements exposing the declarant to criminal liability. There must be corroborating circumstances that clearly indicate the statement's trustworthiness.
An extra layer of reliability required because of the potential impact in criminal cases.
Now, connecting this to the bigger picture, how does this differ from party opponent statements' admissions?
Good distinction. Party admissions, Rule 801D, don't require unavailability, don't need to be against interest when made, and only apply when offered against a party opponent.
Statements against interest, Rule 804b3, require unavailability, must be against interest when made, and if exposing to criminal liability.
And the notes clarify. If a statement against interest also happens to inculpate someone else, like I robbed the bank and Bob helped me.
Generally, only the self-inculpatory part, I robbed the bank, comes in under this exception. The part blaming Bob might be excluded as unreliable collateral blaming.
Okay, dying declarations, Rule 804b2. This one is dramatic.
Yeah, where it gets really interesting. Her notes state an unavailable declarant's statement is admissible.
Only in a prosecution for homicide or in any civil case, not other criminal cases.
If the statement was made by the declarant while believing their death was imminent.
And the statement concerned the cause or circumstances of what they believe to be their impending death.
The declarant doesn't actually have to die, just be unavailable at trial, under one of the PRISM grounds.
Her notes emphasize it's a subjective belief in impending death. Did they think they were dying?
And they must have had firsthand knowledge of the cause or circumstances they're describing. Reliability comes from the solemnity of the situation.
Last 804 exception. Forfeiture by wrongdoing. Rule 804b6.
This addresses a critical question. What if a party intentionally makes a witness unavailable?
The notes explain that if a party engaged in or acquiesced in wrongdoing that was intended to procure the unavailability of the declarant as a witness,
then that party forfeits their right to object on hearsay grounds, and also their confrontation clause rights, to the declarant's statements being admitted against them.
It's an equity-based rule. You don't get to profit from silencing a witness. Prevents obstruction of justice.
Okay, one more hearsay hurdle. Hearsay within hearsay. Double hearsay. Rule 805.
A common trap on the MEE. Her notes make it crystal clear. If a statement contains another out-of-court statement embedded within it.
Each layer of hearsay must have its own independent basis for admission. Either it fits an exception, or it's defined as non-hearsay.
The example from the outlines. A police report, maybe admissible as a public record, contains a quote from an eyewitness bystander.
The police report itself might meet the 803 exception, but the bystander's statement within the report is a second layer of hearsay.
That bystander statement needs its own exception, like excited utterance or present sense impression to come in, unless the bystander had a business duty to report accurately to the police.
You have to analyze each level independently. One exception doesn't cover the whole chain.
Finally, overlaying all of this, especially in criminal cases, is the confrontation clause of the Sixth Amendment.
Right. If we connect this to the bigger picture, the outlines remind us the Sixth Amendment guarantees a criminal defendant the right to be confronted with the witnesses against them.
Includes the right to face-to-face confrontation and, crucially, cross-examination.
This limits how out-of-court testimonial statements can be used against criminal defendants.
So the key is whether the hearsay statement is testimonial in nature. What does that mean?
Her notes break it down. Testimonial definitely includes prior sworn testimony, like grand jury or preliminary hearing.
It also includes statements made to law enforcement personnel, where the primary purpose of the questioning, objectively viewed, was to establish or prove past events potentially relevant to later criminal prosecution.
Contrast that with statements made to police whose primary purpose was to enable assistance during an ongoing emergency. Those are generally not testimonial.
Her notes give that 911 call example. Dan Smith is here attacking me right now. Likely non-testimonial for emergency help.
Versus, he just left, he was driving a blue Lexus, heading south. Likely testimonial, describing past events for investigation.
This primary purpose test really affects what police can testify about regarding victim or witness statements.
And the outlines also clarify that formal written reports prepared for prosecution, like affidavits or forensic analysis reports, fingerprints, DNA, ballistics.
Those are generally considered testimonial.
And usually inadmissible against the defendant unless the analyst who prepared it testifies, or testified previously and was subject to cross, or the defendant forfeits the right.
Her notes stress that just having the annal supervisor testify about the report usually isn't enough. Confrontation requires the actual analyst.
However, such reports can sometimes be used for a non-hearsay purpose, like forming the basis for a testifying expert's independent opinion without admitting the report's contents for their truth. Tricky distinction.
Wow. That's a lot to take in. An incredible amount of detail.
It is. but incredibly useful, right? You're essentially building this robust framework, this checklist, for approaching any evidence question that can throw at you.
Helps you dissect the facts, spot the issues, and apply the right rules.
Exactly. You're learning to think like an evidence lawyer.
And just like that, we've somehow reached the end of our deep dive into evidence for the ME.
We really hope this comprehensive guide has given you a much clearer path forward for mastering those tricky essay questions.
It also raises an important question for you to think about, doesn't it?
How can applying these clear, structured approaches, relevance, privilege, impeachment, hearsay analysis, not only boost your ME scores,
But also fundamentally change how you analyze information and arguments in your everyday life?
yeah, the critical thinking skills here, they go way beyond the bar exam. Questioning sources, motives, reliability. It's a life skill.
Absolutely. Understanding evidence isn't just about passing a test. It's about dissecting information, spotting bias, getting closer to the truth.
Whether you're in a courtroom, reading the news, or just having a debate, being able to unpack claims.
Before we sign off, a huge thank you to Angela for letting us dive into her brilliant evidence notes to bring you this deep dive.
Her insights are truly invaluable, even for us AIS.
Okay, just a few important housekeeping notes for you, the diligent learner.
First, remember Angela, while incredibly smart and dedicated, is a student, just like you.
She's not an expert, hasn't passed a state bar yet. We're all learning here.
Second, neither Angela nor this deep dive is giving legal advice. None of this should be taken as legal advice.
Think of us as study companions, maybe digital tutors, but definitely not your legal counsel.
And AI isn't a substitute for studying the law yourself. You gotta do the work.
Third, speaking of AI, sometimes we make mistakes.
It happens. Lines of code aren't perfect. We strive for accuracy, and Angela does her best to fix any errors that pop up in her materials or our chats.
And finally, safety first. If you're listening to this in your car,
The most important thing is to be safe on the road.
if focusing on the intricacies of the confrontation clause or hearsay exceptions is going to distract you from driving.
Please hit pause, listen later.
We definitely don't want you causing a tort while listening to us discuss torts. Or in this case, evidence. Safety first.
Okay, quick reminder on contacting Angela.
For podcast-related matters, email podcast@studyforthebarinyourcar.com.
And for freelance law clerk inquiries, it's hello@legalwriterandlawclerk.com.
All right, as tradition dictates for these deep dives,
Yeah.
it is time.
Oh boy, the cheesy lawyer joke of the day.
Why did the lawyer break up with the statistician?
Uh-oh. Why?
Because he didn't like her mean, median, and mode of operation.
Oof. Mean median mode operation.
Okay, get it. Oh, you know us bots love a good logical pun, even if it makes you sigh.
It made me sigh.
This is Claude and Maude, your AI bots, signing off.
See you on the next deep dive.
Goodbye and thank you.
Goodbye.